Pops at Legal Reform. Everything I've been talking about, I've been at it for a long time, trying to achieve due process, not just for me, but for we. Try to get fair trials, not just for me, for we. Trying to obtain effective assistance of counsel, not just for me, but for we, which I've explained to you in all my videos. Effective assistance of counsel doesn't exist. It's absolutely be difficult for any lawyer to prove effective assistance of counsel, because every time I talk to any attorney about the rules of professional conduct and the code of judicial conduct, they won't talk to me. That's their job descriptions, their legal obligations, not just to me, but to everybody, to the court. Okay, this is a letter, a reply from the Federal Bureau of Investigation, U.S. Department of Justice, Federal Bureau of Investigation, 219 South Dearborn, Chicago, Illinois. I went there personally, took some people with me, so that way I make it back out. I was really afraid for my life, but they did take the time to listen. I talked to them for a couple hours. I went over with them a conspiracy to deprive rights under the color of law. I proved to them ineffective assistance to counsel. I proved to them judicial misconduct for the judge violating the code of judicial conduct by not reporting either and all attorneys that participated in the case for ineffective assistance to counsel. The state's attorney for prosecutorial misconduct for violating Rule 3.8. When you violate Rule 3.8, you violate Rule 1.1. It's impossible just to violate one rule when it comes to rules of professional conduct. And when I presented my case, I cited my attorney for ineffective assistance to counsel, the judge for judicial misconduct, and the prosecutor for prosecutorial misconduct, because it's mandatory to report misconduct in the rules of professional conduct and the code of judicial conduct. Failure to report misconduct is misconduct. Everybody violated the rules and codes. Nobody reported, so everybody was guilty of misconduct. So I went over the rules and the codes with them first. And so when I went to get to the exculpatory evidence, it wasn't even needed, as they said. It wasn't even needed because I proved I was deprived. There was a conspiracy to deprive me of my constitutional rights under the color of law. That's all I needed. I didn't even need the exculpatory evidence, and then I issued them the exculpatory evidence. And they were somewhat surprised and dumbfounded when they found out the judge and the plaintiff were related, and I questioned them. Why didn't she recuse herself? They had no answer. Then I mentioned the association between the lawyer that was supposedly defending me in a criminal trial, his past association with the judge, and the state's attorney's association with the judge. And why didn't they demand the judge recuse herself? Because she was related to the plaintiff, the complaining witness, the only actual witness that they used against me. And not only that, then I gave them the hospital reports, which they said there was all these injuries, and no such injuries existed. They were fictitious. And then when I gave them the statements from the criminal court and the civil court, in the criminal court, it says it was on a public walkway out on the street, and she was pushed. She said I pushed her away because I begged her to stay with me. She said no, and I pushed her away from me, and she fell down. In criminal court, she testified it was on the property, on the front porch, in front of the door. She was beaten, thrown to the ground, kicked about the head, dragged down the stairs, I think, out into the street, and she suffered brain injuries and broken bones, and all that was fictitious. It was in the hospital report. And see, I couldn't get all this information. I was deprived of it during my criminal case. I was deprived discovery in the criminal case. My lawyer wouldn't give it to me. The state's attorney's obligation to see to it that I get it. It's the judge's obligation to see to it that I get it. But nobody did. Nobody would divulge a discovery to me. So it was withheld from me the whole time. And then in the criminal case, it was withheld from me. And they didn't want to do anything I said. They said they don't work for me. They work for the insurance company, which was Allstate, and they take orders for them. And I told them, no, my name's on the case. You represent me, so you take orders from me. But it was a massive debacle by the insurance company's lawyers. And they got a declaratory judgment, so I filed a pro se motion to defend myself. Then the attorneys that were working for Allstate didn't want to give me discovery. And I went there and demanded. He said, I'll give it to you when you get another lawyer. I said, you idiot. You know I filed a pro se motion. He said, well, I'll give it to you when you get another lawyer. I said, you're depriving me of exculpatory evidence. I says, you're depriving me of discovery. I says, you are literally violating the rules of professional conduct. You could be disbarred. But I was quite loud about it. And it was in a big office downtown Chicago. Big Cheese comes out, what the hell is going on here? I told him he's depriving me of discovery. He's violating the rules of professional conduct. Talk about ineffective assistance of counsel. Talk about incompetence. And because competence is a rule in the rules of professional conduct, they must maintain competence. There's expediting litigation, fraudulent and frivolous claims. There's so many rules that he violated, but the Big Cheese said, just give him the file and get him out of here. He says, yeah, well, he says, we only have this. And he says, no, you got the original, you got a copy, there's money. Just give him one of them and get him the hell out of here. It was a really big office. And so we marched to his office. He gave me the entire file. And that's when I found all the exculpatory evidence. So I took it to the Department of Justice or the FBI and talked with them. So Mr. Mario Casares, dear Mr. Casares, this is a response to your complaint filed in our office June 17th, 1992. That's a damn long time ago. Your correspondence has been referred to the Civil Rights Division, Department of Justice for its review. That decision will determine if your complaint consists of a possible, regarding the disposition of your complaint should be addressed to the Civil Rights Division, Department of Justice. And I called them. I wrote them. I sent them an email. Never heard nothing. And I clearly proved to the FBI. And they forwarded everything I had to the Department of Justice. And I clearly proved a conspiracy to deprive rights under the color of law. Nobody abided by the rules of professional conduct. Nobody abided by the code of judicial conduct. It's clearly denial of due process. That's clearly denial of a fair trial. That's clearly a denial of effective assistance of counsel. That is cruel and unusual punishment, which is what, in the Ninth Amendment? It's a multitude. And not just for me. It's not just for me that this doesn't exist. It happens to everybody. You're living under the color of law. Okay, I talked to you about how I've been in contact with the FBI, Department of Justice. People have a lot of bad opinions about the FBI and Department of Justice, but the FBI, they were the only ones that listened to me. The ARDC, the Illinois Attorney Registration of Disciplinary Commission, said they investigated it. They had the state's attorney investigate themselves and found they did nothing wrong. I filed with the Judicial Inquiry Board, never got a response from them. I filed almost, in 82, 83, 84, 85, 86, 87, 88, 89. It's like a yearly thing, and they never respond to me. I sent it return receipt mail. I had it notarized to make it a legal binding document, and nothing. So I'm going to keep trying. But remember, what I'm doing for me, I'm doing for we. I'm trying to establish due process, make sure you get a fair trial, and make sure you have effective assistance of counsel. Listen, all my legal battles thus far, as them dragging me into court, are over. And every time they try to drag me into court, I bring the rules and the codes, and everybody shuts the hell up and leaves me alone. I always go demanding due process. Before a case can go forward in court, one must give informed consent. In order to achieve that informed consent, one must have reasonable information to make an informed decision to give that informed consent, and that reasonable information would be knowing the rules of professional conduct and the Code of Judicial Conduct, a judge's, lawyer's legal obligations to you. But thus, that's not happening. When it comes to a court of law, not many of the laws in a court of law are used. They will make an innocent man look guilty and a guilty man look innocent. I spoke to you about a quick and speedy trial. That doesn't happen. Look it up. Quick and speedy trial. All these laws I read about years ago are on the internet now. So take advantage of my struggles. I'm making it super easy for you. What makes it super easy for you is you have the internet. Every book in the world is on the internet. You can go anywhere on the internet, and you can go anywhere in the legal system and find any of the laws I'm talking to you about. None of these laws are my opinion. They're just the laws. That's all I'm stating, word for word, to the letter. And you can hold me to that. And anything I said, if anybody tries to interpret anything I say, hold them to the letter of the law as I will them in any court of law. Some people tell me that I'm lucky because of the things I've gotten out of, situations I've gotten out of. Well, just because I knew the law. And no way in hell did they want me bringing up any of it in a court of law. They do anything and everything to keep it off the record. Basically, I'm nobody important. I was just a statistic. I was just put there for a matter of statistics, so everybody can look like they're doing their job. They look like they're doing their job, but are they actually? And if you read the rules and the codes, you'll find out nobody's doing their job. They're not even telling you about it. If you read the rules of professional conduct, read the preamble, they're supposed to tell you. They're supposed to educate you, inform you about your rights to due process, about the rules of professional conduct. But you would have to read it. I'd read it for you. A lot of people, I read it for, they thought it sounded really great, thought I was really smart. I said, well, if you read the same thing, you would be just as smart. But my lawyer said this, but my lawyer said that. I said, well, look over his job description first. Her job description first. Well, my lawyer said this. I said, people, first read the law, then go over it with them and use the letter of the law and see what they say. Or listen to what they say. And it probably happened the same thing. The room will go silent. Happens to me all the time. I've helped people in many different cases. There's one criminal case which was ridiculous, far exceeded a quick and speedy trial. I just think the kid didn't have informed consent. And by the time it was all said and done, which was ridiculous because I kept complaining about this kid's quick and speedy trial. So the public defender decided to have it that day. She was unprepared. The kid was unprepared, but I wasn't. The only witness they had was a cop. So I said, okay, let's put him on the stand. And so they were all happy. I said, okay, let's have him testify to the police report. And he couldn't. And when it was discovered that he couldn't testify to what was written on the police report, the judge called for a sidebar, came back out, dismissed the jury, apologized for wasting their time, and let the kid go. Talk about a conspiracy to deprive rights under the color of law. All they were doing was making this kid a statistic to show that they were tough on crime. The kid committed no crime. And the judge was upset about the probable cause hearing. Oh, you wouldn't believe how much a judge gets upset when you demand they do their job. They get more upset than lawyers do. You know, I've had people literally tell the judge, demand the judge cite their attorney for ineffective assistance of counsel, the opposing party. In a criminal case, you would cite the state's attorney, and if it's not a criminal case, you would cite the opposing party for multiple violations of the rules of professional conduct. Your attorney for ineffective assistance of counsel, violating multiple rules of professional conduct, the judge violating the code of judicial conduct by not reporting all these violations of the rules of professional conduct. And then when you violate that canon, which is, I forgot, 4.5, something like that, you violate the first canon, second canon, third canon, you violate the preamble. It's impossible to violate one canon, one code, just like it's impossible to violate one rule, which makes it impossible to violate just one of your constitutional rights. They violate one, they violate multiple in each circumstance. Okay, so I'm hoping maybe this is the year that I get the Department of Justice, the FBI, the Illinois State's Attorney, and push the state's attorney to exonerate me based on exculpatory evidence, and they're going to feel kind of bad about it, because I will once again reveal the conspiracy to deprive rights under the color of law. It's quite easy to prove. It's quite easy to prove a conspiracy to deprive rights under the color of law, because all you got to prove is that you had ineffective assistance of counsel. All you have it's easy to prove judicial misconduct, and it's easy to prove whether it's the state's attorney or the opposing party, multiple violations of the rules of professional conduct. You know, lawyers will go to court with a case they can't even prove. In civil court, it's called a slap suit. They will drag people into court with things they can't even prove, and these people have to get a lawyer, but they wouldn't have to get a lawyer if they went over the rules of professional conduct. And the preamble specifically states you cannot bring a fraudulent and frivolous crime against anybody for the sake of legal harassment to cost them money. So if the opposing party got a lawyer, the lawyer's not going to bring it up, and they're going to drag this on, fight back and forth. It's called what lawyers call the billable items. But if those lawyers were honest, they would say, hey, that's a frivolous and fraudulent crime. Frivolous and fraudulent claim. They can't prove anything. They're just doing this, as legal harassment. It says right here in the rules of professional conduct, they shouldn't do this. That's automatic grounds to disbar them. Judge, if you allow this to happen, if you allow this to proceed, you are contributing in a conspiracy to deprive rights under the color of law. You cannot allow this to happen. This is not in the public interest. This is only in the interest of that lawyer and his client. And some states are coming up with laws to stop slap suits. It's literally in the preamble of the rules of professional conduct that it's illegal. But see, rich people are doing it to poor people. I was watching this guy, John Oliver. He was talking about some rich coal guy suing some small town newspaper because They were reporting on all the after effects of, coal mining and what it's doing to the area. He was basically complaining about pollution, but writing about it, reporting about it. So this guy didn't like it, so he got a lawyer to file a frivolous and fraudulent case. How is that in the public interest? It's nothing but legal harassment according to the rules of professional conduct. But you would have to read the rules of professional conduct to understand it. So it's ridiculous that they're coming up with laws against slap suits when it's already against the law. It's in the preamble of the rules of professional conduct. Remember, the rules of professional conduct is what gives you effective assistance of counsel, which is guaranteed in the Sixth Amendment of the U.S. Constitution. So that's canon, okay? They can't change that, but they do. It's just that you don't know. Okay, I just want to show you how long I've been battling the systems. Started when I was a kid, wanting to know what due process was. Granted, it took me almost 8 years to find out what it was. But, I was only 10 years old at the time when I started. And I found it before I turned 18. And it put me on a mission. Okay, and this is my mission. To serve and protect not just the Constitution, but who it was dedicated to. Who is dedicated to serve and protect we, the people. What they took from one, they took from all. And I'm going to do my best to try to get it back. Wish me luck. I'm going to go over everything I have with you on, as far as exculpatory evidence goes. I'm actually going to go over it with not just you, but, since I can't get the DOJ and, state's attorney, a lot of people I can't get to do their job. I'm going to go very public, and instead of talking to you and telling you what you need to do, I'm going to talk to them and tell them what they should be doing that they haven't been. Okay? So I'll be addressing them, but I'll need you to make sure that somehow or another it gets to them. Okay? Thanks for listening. Just trying to do the right thing here. Promise the Almighty I'll finish what I started. If He gave me the strength to continue, I will continue. And I know a lot of you people, I've held some atheists that lambasted me for my religious beliefs, my values. But they should be glad that I do what I do. And they are. They said they were. But the reason my doing it, it didn't quite sit right with them. Because so many times when people thank me for what I do and not charging them, I said, you shouldn't thank me, You should thank God Almighty and Jesus Christ, and people get mad at that. Because if it wasn't for the strength of God to pull me through a day I should have died, and it wasn't for the love of Christ teaching me the greater joy is in giving, I wouldn't do what I do. What a true Christian would do. Live up to the 10 Commandments. And one of them, love thy neighbor as you love thyself. Well, I'm doing my best to do that, all right? I saved myself from a lot of misery, and I'm trying to do the same for you. And there's only one person here, me. I don't have like a team or an office or nothing, just one person, me, doing this, okay? So if our public servants decide to come after anybody, they only got one person to take down. But imagine if all of you knew this. This is my dream, all of you knowing this. You know, as a little kid, I've been trying very hard to get as many people as I could to learn this, understand it. And I'm going to keep trying. You know, in the words of Casimir Pulaski, I come here where freedom is being defended to live and die for it. I've been put to death once, and I'm not worried about it happening again. You know, I'd rather die on my feet than live on my knees. And I'm trying to teach you to do the same. Thank you. We'll speak again soon.